Thank you, Greg. Our next speaker this evening is Senior Assistant Attorney General Jeffery Strelzin. Attorney Strelzin is a New Hampshire native. He received his bachelor's degree from Keene State College in Keene, New Hampshire, and his law degree from UNH School of Law in 1991. After graduation from law school, he spent 2 years working for the New Hampshire Superior Court. After his clerkship, Attorney Strelzin worked at a private law firm in Manchester as an associate handling civil and criminal litigation before becoming an assistant county attorney at the Merrimack County Attorney's Office. In 2001, he joined the New Hampshire Attorney General's Office, where he has spent the last 11 years as a prosecutor in the Criminal Bureau and Homicide Unit. Attorney Strelzin is currently a Senior Assistant Attorney General and Chief of the Homicide Unit, a position he has held since 2004. In addition to overseeing the day-to-day functions of the Homicide Unit, Attorney Strelzin also oversees and prosecutes homicide cases throughout the state. In 2008, Attorney Strelzin was part of the prosecution team that successfully prosecuted the case of the state of New Hampshire versus Michael Addison. Attorney Strelzin was also the lead prosecutor in the cases against Stephen Spader, Christopher Gribble, William Marks, Quinn Glover, and Autumn Savoy, who were all charged in connection with the home invasion and attack on Kimberly and Jamie Cates in Mount Vernon in October of 2009. Spader and Gribble's cases both went to trial, with Spader being convicted in 2010 and Gribble in 2011. Both defendants were later sentenced to life without parole in prison. The other 3 co-defendants pled guilty and received long prison terms for their roles in the crime. Please welcome Attorney Strelzin.
Thank you. It's a pleasure to be here. Ignore everything Greg said. That's pretty much all I have to say. I'm kidding. It's actually, we probably agree about 90 to 95% of the time. The criminal area is a little bit different for the right to know law because, as Greg explained to you, there's an exception there that's built in for us, and we're a little unique versus other state agencies that just do civil work. And essentially the best way I can put it is that the public does have a very broad right to know, but it's not unlimited. And Greg told you about some of the exceptions. And in the criminal realm, in criminal investigations, especially investigations that are pre-indictment, meaning before we've indicted someone, the right to know, the public's right to know, is very limited. And essentially the reason is this, that in the United States we've decided that it's important to try cases in a courtroom and not in the media, not out in the public. That's something that, depending on your perspective, you might not always agree with. Certainly, often when we talk to family members of victims, they're frustrated with the process. They feel like it's too protective of the defendant. But certainly, if you ever have a friend or family member who's been in trouble with the law, I think you'd agree that you and they appreciate all the rights that are afforded criminal defendants. And one of the important rights is the fact that, again, we try our cases in the courtroom and not in the media. The other reason that the right to know law is limited when it comes to law enforcement activities at certain stages is that the law gives us, prosecutors and police, a chance to investigate and solve the case. If we tell our suspects out there what we're doing and what evidence we have, it would make it very difficult or impossible for us to solve cases. And so we're allowed a window. It's typically a pretty short window, but we're allowed a window where we're allowed to operate, I won't say necessarily in secret, but where we don't have to disclose publicly what we're doing. Not just to the public, but to suspects, potential defendants in a case, and potential witnesses. And again, the idea is that we want to give police and prosecutors the chance to solve these cases and to give them the tools that are needed. And it's hard to explain all the time why, but I will tell you that secrecy is one of the most important weapons that we have in law enforcement. Our ability to do things and not tell the people that we're targeting what we're doing is often the difference between solving a case and not solving a case. And the things that we do aren't necessarily secret. It may be specifically how we do them, when we do them, and exactly where we're doing them. And so we need the ability to be able to do those things in order to solve our cases. Pretty much the rule in New Hampshire is that it's determined on a case-by-case basis, meaning depending on a particular case, we may be able to keep things secret for a very short period of time or for a very long period of time. And Greg had mentioned the Bowman search warrant case, and I'll talk about that case for a minute because that's actually a good guidepost for what we're allowed to do and what we're not allowed to do. That was a July 16th, 2001 case that went up to the New Hampshire Supreme Court. What happened is this. Our office was investigating the disappearance of a mother and a daughter, the Sinclairs, over in the western part of the state. They went missing, and we began a criminal investigation in conjunction with the state police. As part of that investigation, like many of our investigations, we went and obtained search warrants in the case. And those search warrants were obtained from a local district court, and those search warrants were sealed. Greg talked to you a little bit about that. In order to have search warrants sealed, we have to file a motion with the court and justify why we want those search warrants sealed, and we did that in that case. A local newspaper found out that we had done search warrants. They didn't know what we'd done, and they asked the court to unseal those search warrants. And the court held a hearing, and they ended up ordering us to turn over, they ended up declaring that those search warrants would be unsealed. We asked the court to stay or to temporarily halt this decision, and then appealed it up to the New Hampshire Supreme Court. And on July 16th of 2001, the New Hampshire Supreme Court came out with this ruling. And essentially what that ruling says is this. The court said that the district court was wrong, and that generally speaking, when you have an ongoing criminal investigation, and the case is in the pre-indictment stage, meaning no one's case has gone before the grand jury to be formally charged with a felony, that generally speaking, that is a justification to keep the search warrants and the investigation secret. It's kind of a bright line rule. In other words, it pretty much told the media, it told the public, and it told the police and prosecutors generally what the rules were, which is it gives us, meaning police and prosecutors, a limited period of time, generally, to investigate a case. Why do I say limited generally? Because the Bowman case is actually still going on. That was back in early 2001. We haven't been able to solve that case, but everything is still under seal. And the reason is it's still an ongoing investigation. And if we were to reveal publicly what we learned, things that we know, that could hurt the case. But generally speaking, it's limited, meaning we hopefully, knock wood, make arrests fairly quickly in most of our cases. And once we go and get into the courtroom and indict someone, from that point on, it would be difficult in most of our cases to assert to a court, hey, you need to keep this stuff secret. Because once our cases are out there in the public, once things are in the courtroom, and we start to put our cases out there, it'd be hard for us to justify to a judge with a straight face, all that stuff we just talked about in the courtroom, you still need to keep it secret. So once we reveal information about our cases in the public, at that point we typically lose our justification, and whatever documents are on file in a court are unsealed. What we try to do in our office is these things aren't indefinite, and so once our justification ends to keep things sealed, we typically file a motion to unseal with the court, and they're unsealed. Sometimes it's the media who does it, and they'll contact us and say, hey, we want to file a motion to unseal. What's your position? A lot of the times we agree, sometimes we don't, and then we may end up in court and figuring out what parts of our documents can be sealed, continue to be sealed or unsealed, and that's typically how it happens. But in New Hampshire, we have a bright line rule set by Bowman. If it's pre-indictment, it's an ongoing criminal investigation. Usually we can keep our court documents sealed. Let me talk to you a little bit about why police and prosecutors are or should be reluctant to talk to the media. In New Hampshire, I think New Hampshire is a different place. I mean, when I cringe sometimes when I watch TV and I see some of the things that police and prosecutors say to the media about cases. They hold up pictures of the victims, or they say things about the defendant's prior criminal history. This guy's guilty, he confessed, things like that, and I cringe. And the reason is that in New Hampshire, the rules that apply to police and prosecutors are really pretty strict. Lawyers have to operate under what's called the rules of professional conduct. There is a specific rule that talks about what lawyers, meaning prosecutors and defense lawyers, can say to the media. There's a special rule just for prosecutors that's targeted just at us and limits what we can say. The thing about that rule about prosecutors is it not only makes me responsible for my mouth, it makes me responsible for all the mouths that work with me and work under me, meaning the police who are investigating the cases, paralegals, secretaries. I have to take reasonable steps to make sure that none of those people say something that I otherwise wouldn't be allowed to say. If they do, I'm responsible, meaning the state, we're on the hook. What does that mean? That means that if somebody says something they shouldn't, a defense lawyer might be able to file a motion to suppress. For instance, if somebody were to talk about the defendant's confession, something we can never talk about publicly, they were to talk about that, a defense lawyer might take that newspaper article, attach it to a motion, and go into court and say, Judge, this guy mentioned my client's confession. I want you to toss that confession out. Or I want you to dismiss the charges. And so I won't say we're terrified, but we're very cautious and careful about what we say to the media, because not one of us wants to ever have to say to a family member, I'm very sorry about your loved one's case, but guess what? I spoke out of turn, or someone else did, and that piece of evidence has been suppressed, or the charges have been dropped. So never mind the fact we can be disciplined and potentially face consequences by the lawyer disciplinary committee. It could also impact our case. And so that's why in New Hampshire, prosecutors are very careful when they talk to the media, and we try and make sure that the people who work with us on cases are just as careful as well. I think that we have a pretty good understanding, though, of the balancing. Obviously, we need some level of secrecy to solve cases. That's important. I mean, that's what the public wants us to do. At the same time, there's a tension, as Greg talked about, with the public's right to know. The public has a right to know, and they should know what we're doing. They pay our salaries. So often we have to do this balancing. We do it between, is it okay to release that? What should we release? What's okay to tell the public? When can we tell the public? And we try and do that balancing. And we certainly are very cautious in that, and we try to be careful about what we say. But we understand that there's a benefit to that. It's important that people know what we do. What we do is an important job, and we want the public to know it. Also, the media can be helpful in some of our cases. There are times when we want to specifically release certain information to the media. We may have a murderer on the run, or a suspect who's missing, or maybe there's evidence that we're looking for, and we want to enlist the help of the media. So there are certainly times when we'll decide to put out more information to try and enlist the help of the public and the media. But there is a tension, and it's constant and ongoing on all of our cases, and we constantly have a discussion about what can we release, what should we release, and what's the timing of that. And that happens in every case. Because in our office, we don't have public information officers. We don't have people who deal with the media. The lead attorney on every case is actually the person who has to do that. And I certainly, before I became a prosecutor, never had any training in that. And I can remember the first time a camera appeared in my face, a reporter called me, and I was terrified. And I'm a little terrified now sometimes, depends on who the person is, but it's difficult. And again, in the back of our heads, just what's going on, it's, oh my God, can I say that? Oh my God, can I say that? Did I just say too much? Ouch, because you can't take it back once it's out there. But the way it works in our office is that the lead attorney on each case is tasked to deal with the media. And the reason we do that is, number one, resources. We don't really have enough to hire somebody. But the second is actually it's a practical thing, which is nobody's going to know the case better than the lead attorney on it. And isn't that the person you want making the decisions about what's right to release or what you can release versus not? Because if I had a public information officer, I'd have to call that person at 3 o'clock in the morning when I'm out there and say, okay, here's what I got, here's what I have. And you know what happens when you keep passing it along to every individual person, that game where by the time you get to the end, it's like, what is that you just said? So as much as it can be a hassle sometimes when you're out there juggling everything else, we've decided that our lead prosecutors on the cases will also deal with the media in the hopes that the media gets the most accurate information and we comply with the rules of professional conduct and what it takes to solve cases and hopefully don't make mistakes in the process. But it's an ongoing process, meaning, if Kathy Marchocki calls me tomorrow about a case, I may say to her, Kathy, we're 12 hours into this. I just can't comment on that right now. But maybe 12 hours later I can. Maybe 24 hours later. It all depends. And so it's constantly evolving and shifting. At different points in the case, we may not be able to say A in the beginning, but we can say it later on in the case. But I just want to say, even as to all that, if the case hasn't gone to trial yet, we're still going to be very limited in what we can say. And again, the overriding concern is that a defendant should have his or her case tried in the courtroom. So what happens? What are some of the things that happen if a lot of information gets out in the media, if things get released? There's some practical realities that happen with this. Number one, what we see is we see it when jurors come in and have to go through jury selection. Defense attorneys will file motions to change venue, claiming that there's been so much media attention on a case that their client can't get a fair trial. And that engenders a lot of back and forth between the parties and litigation. The second thing that happens is it makes it very difficult for us sometimes with witnesses. When we meet with people, we always want to know, hey, John, do you know this stuff because you know it firsthand, or did you read about it? And the media is very pervasive in our life now, between print media and the internet and social media. Unfortunately, sometimes I will get a call from a media outfit asking me about a murder before I've got a call from the state police about a murder. And it happens maybe 10% of the time. Or I get a call saying, hey, Jeff, is there a murder in Salem? And I'm like, don't know what you're talking about. Click. And then the pager goes off, and I go and say, hey, what's up? Oh, there's a murder in Salem. No kidding. Everybody wants their 15 minutes of fame, but it's also just how quickly can you text somebody and say, oh, my God, guess what happened next door? And people are posting it on their Facebook accounts, and the media is tuned into this stuff, and so that happens. But for us, the problem is that means that the information pool can be diluted. We need to make sure that person, when they tell us things, they're telling us those things because they know it, as opposed to, well, actually, I read it, I heard it from someone else. The other area where it comes up a lot is, I'm sure you've heard of cases where we have, some people call them snitches or rats. We like to call them cooperating individuals. But these are individuals who might be in a jail or a prison with a suspect that we arrested. Or maybe they're a suspect in another case, we haven't arrested them on our charges yet. And this person comes forward and they say, hey, I was in the other day with your guy, and these are all the things he told me. One of the first things we have to do is try and figure out, is that person being credible? And what we look at is, does that person know anything that only the killer would know? And so we've got to sort through and say, what's been out in the media and what hasn't, and try and figure out, is it truthful? We don't just do it with that cooperating individual, that snitch. We do it with other witnesses who come forward. Unfortunately, some people have issues, and they will take responsibility for crimes they haven't committed. It's rare, but it happens to us occasionally. One of the ways we can figure out if they're being truthful is, are they giving us information that only we know in the investigation, that only the killer would know, or are they simply regurgitating stuff that's been out in the media? And so that creates work for us that we've got to go through and sift through all that. But I can tell you it's critical in most of our cases that we withhold some information. We have these nuggets that only we and the killer would know, and we're able to use that as a lie detector test with witnesses and with suspects to be able to figure out, do they really know it because they were first-hand witnesses, or they got it directly from someone who did, or do they simply go online and find it somewhere? And so that's one of the tensions that exist between, the public wants to know what we know, and the fact that we want to protect ourselves. And I will tell you that, I'm often subject to some blistering questioning, pretty much from my 92-year-old Nana, who always says, say to me, I want to know, tell me, I'm your grandmother, you can tell me, it's okay. And, she's interested in these cases, and the cases, the work that we do is interesting, and certainly we want the public to know about it. But at the same time, our job is to enforce the laws, and to do that, we need to catch the criminals. And so we understand that there's that tension between the fact that the media wants to know, the public wants to know, but we need the tools to solve our cases. And that's why you'll see sometimes that we end up in litigation. I don't think there's actually been a ton of litigation in the criminal realm with our office as far as right-to-know stuff. I think it tends to be more civil. But there are some times when, like the Bowman search warrant case, where we will essentially get into a dispute with the media about what we can and cannot release. But it's surprisingly collegial, it's surprisingly cooperative, and most of the time we can agree on what we're going to release and when. Sometimes we can't, and then the courts resolve the issue, and that's how it works. So the best way I can sum it up is there is a tension between the public's right to know, and there's a tension between our desire to get the job done, not to be disbarred, which would be a good thing, or to get in trouble on a case. And we try and balance all those things and put all those balls up in the air. It doesn't always work, but for what it's worth, our intentions are good. But we do understand the public wants to know what we're doing. And in some cases, we simply feel we can't tell them until we make the arrest. Otherwise, we're going to endanger the investigation. And that's pretty much the tension that we work with every single day on these cases. All right.